Well, once again, good morning. We're going to jump right into this particular session. I know we have some virtual attendees as well. From the last session, we are sending the handouts for Be a Giant Killer through to Stacy and Shannon and the team to post those handouts that the in-person attendees received. And also we will do the same thing for these session handouts as well that you have. We want to just thank again Wendy and Meredith and Kiet and Team HFMA Oregon for the invitation. Anu, my COO, and my wife, my better half, she's going to pass out just some of the handouts for today. We want to thank you for also the extraordinary service in which you have provided to humanity in this pandemic for the last 2.5 years or so. Your lives have saved so many. People you never meet are here today because of your unwavering commitment to defend human lives and your healthcare delivery system. Because our commitment increases in conflict. Our commitment increases in conflict. We talked earlier in the session about the difference between transactional and covenant relationships. Lawyers practice law, politicians practice politics. We practice covenant and or medicine. We build covenants, not transactions. We build stories, not silos. And we learn from the relationship and the conflicts that have shaped us. Here's a question. How has your covenant, your promises, your commitments to people and to patients survived the past 2 years? The COVID pandemic caused many of us to face giants of immense size we never imagined would creep into our lives. Things like how to work remotely, how to do conferences virtually, how to isolate, how to quarantine, how to pray, how to protect ourselves, how to homeschool our children, how to increase authorization and revenue capture while away from a facility, how to preserve a healthcare delivery system that's crippled by surges and capacity, how to be a better human, better neighbor, better spouse, parent, or relative, how to cope with disagreements and fractured covenant, relationships over vax or no vax, mask or no mask, how to face payors that just won't listen despite worldwide chaos. And we exist to grab the attention of patients. We recently had a chance to represent a patient pro bono who was in the Bay Area. She's from Tennessee. She's a hiker and she's involved in some environmental stuff. And she was on her bike in the wilderness, I guess, hit a rock, flew off of the bike, broke her collarbone. And her insurance would only cover out of air emergencies. So when she went to the ER, they covered that. But then she needed surgery and she couldn't get back home for the surgery. And so what we learned is that her condition was a continuing emergency. She had a continuing emergency that was going to take place a week later, but it didn't have a 450 code, it didn't have the codes to signify it was an emergency. So Cigna denied it, stating that it wasn't emergent and we're not going to pay it. And they sent her a bill, the hospital sent her a bill for $40,000. I was really bothered with it. This hospital I used to represent before United Health brought them out. I called a VP at the hospital that I still do that was there and said, listen, we have a concern. A few things. Number one, this was a continuing emergency and we don't feel it was billed correctly. And so she talked about V codes and other codes that I don't even know about, but she explained that. I also shared with her, well, under Tennessee law, unless you guys have had her sign this type of documentation that says she's going to be responsible for this before the service was rendered, under Tennessee law, you can't charge her for anything. Make a long story short, we filed a complaint with the Tennessee Department of Insurance. And really it was an uphill battle because the surgery, even though it was a continuing emergency, there's nothing on the bill that would delineate that it was an emergency. So they were denying it. And they stood fast on the fact that this service, if it's not an emergency, we're not going to pay it. Filed a complaint. Just got a response back yesterday that Cigna again stood to their position. At the very bottom of it, they said, however, since the patient was away from home and couldn't get home for the surgery, we're making a one-time to pay for these bills as in-network. Furthermore, we'll pay for her urgent care bills as in-network as well, thus eliminating this $40,000 bill for this particular lady. And really, we exist to deal with the payers that don't listen, to take the difficult cases that other people say, man, it's impossible. We're not going to overcome that. There's no way we're going to challenge that. I mean, we exist literally to try to walk on water and perform miracles. And I want to encourage you with that, because oftentimes in office culture, certain denials are passed over by individuals as impossible. And the only way we can make our mark in the industry and be distinct and work in a way that where people see us and they say that our work is remarkable is we have to do something worthy of remarking about. We often will train at different locations, and we will travel into a city and train a hospital on administrative laws that should be streamlined throughout the entire revenue cycle. And we will stay a week on site, and we will just simply shadow the doctors and the nurses. We will shadow the case managers, the admission reps, the back-end folks, and we'll give them findings and recommendations and show them how they could streamline laws in every department. And oftentimes when I'm there, I try to have a visible work case study that I leave with. So in addition to all this different work of consulting, I'll say, give me your top 5 most difficult cases. And I'll show them how to apply the administrative laws on those cases. And I could say to them, Kiet, at the time, hey, we're going to send this letter out, but, by law, the plan has 30 to 60 days to respond to you. Let us know what happens. And they'd be totally okay with that because they're accustomed to receiving responses beyond 60 days, right? Or in that time period. But that would be no fun. So we go in and we state, hey, listen, we're going to try to get a different result in the next 7 days. Before we leave here, we want to get a result on this case that you have. And we want to do the impossible. And 99% of the time when we've done that, we've been able to generate. The last one I did, we overturned $4.5 million in authorizations that were pending from the state in a very short period of time. Because it challenges me to be able to do that, but also to give people inspiration that they could do that. They could do something different. They could challenge giants who are in the industry that are challenging their ability to practice medicine. And so as we have come through this time of pandemic, many people have faced the giants, and they've crossed over the graveyard of their greatest fears, and they've showed up every single day, oftentimes afraid. They've stood, they've fought, they've appealed, they've protested things that were bigger than them when they had nothing left. And as we talked about earlier in the session, there's a generation that needs to know how we survived. They need to know the stories that we have built through our overturns against Medicare Advantage, against commercial payers. They need to understand how to be set apart and how to work with great passion so that people remark about what they actually do. And I'm seeing, as I'm getting in the industry, traveling more this year, I'm hearing about stories all around the world of people who are becoming storytellers of how they survived in the pandemic. And they're documenting stories of overturn, stories of hope, of resilience, of inspiration. I mean, here's one that I love sharing. It is actually at New Orleans Ochsner Medical Center. And doctors and nurses and other workers found encouraging messages written in chalk outside the hospital they worked in. Messages like this one, and you can't see it that well, but I'll read it to you. If you're arriving, thank you for what you're about to do. A little further on, they read this as they were coming in. Simply, you are extraordinary. And for those finishing their shifts, one wrote, if you're leaving, thank you. Rest well. And there were more that we saw. If they were coming in, inhale. As they passed by this sign, leaving home, it said exhale. And then, of course, I love this one. Not all heroes wear capes, but many wear scrubs. And it didn't cost a dime for these messages to be scribbled on the sidewalk and make an impact. And so we don't have to publish our story in a book, but it should be written on the lives of the people that we lead, we love, and we influence. Write this question down if you're writing with me today. What will you write in the next chapter of your life, the next chapter of your career, to inspire people for you? What will you leave behind in this chapter of life? How can you live for impact and not income? We enlisted into healthcare to give people what they couldn't give us, and we do that by maximizing the human experience. We do that by giving people the courage to face giants or conditions and diagnoses stemming from family history, from patient history. We do it by challenging denials and decisions that impair our ability to practice medicine. We spoke about this a bit, about Cooper recently, and I talked to you about how Cooper was a 6-month-old baby who had a disease that mimicked polio, as you can see at the very top, and he was misdiagnosed for the first 2 months. And you'll see that he had paralysis because of his spinal cord that was swelling from the brainstem to the T7. On 10/5/18, they inserted a trach because he couldn't breathe on his own. On 10/23/18, they consulted a doctor who was a rare neuroimmune disorder specialist who referred Cooper to KKI in Baltimore, Maryland. And then, of course, they said on 1/23/19, and this is what the mom wrote to us, so forgive her misspelling, but you know what she's trying to say, does not meet MCG guidelines. Just for a moment, talk to me. In this area, this region, do you see denials as not meeting interqual or MCG guidelines at all? Do you see that? All right. Talk to me for a minute. Let's interact a little. Tell me how you normally challenge those denials. Talk to me. What do you do? You got one, you see it, you're looking at it, we're in the room together. How do we fight it? Talk to me. Anyone. What do we do? Look it up. Good. Okay. Okay. Absolutely. So we look it up to see if we can fight it, right? And we should be doing that with the physician, right? So to some degree. Here's a way that we challenge this issue. We use the interqual or the MCG guideline against them. And here's what it says. Here's interqual, and I'll show you MCG in a minute. Interqual's guideline says this. Per the Change Healthcare disclaimer, interqual is not intended to be used for final clinical or payment determinations concerning the type or level or medical care provided or proposed to be provided to a patient. And it reads in pertinent part, the clinical content reflects clinical interpretations and analysis and cannot alone either resolve medical ambiguities of particular situations or provide the sole basis for definitive decisions. The clinical content is intended solely for use as screening guidelines with respect to the medical appropriateness of healthcare services and not for final clinical or payment determinations provided or proposed to be provided to a patient. MCG says this. The website and the content are for information and education purposes only. The content should not be used to replace any written reports, statements, notices provided by MCG, and professionals and other persons should use the content in the same manner as any other educational medium and not rely on the content to the exclusion of their own personal judgment. MCG does not warrant the accuracy and completeness of the content or the reliability of any statement or information displayed or distributed to the site. They continue, the care guidelines are not intended to be used without the judgment of a qualified healthcare provider with the ability to take into account the individual circumstances of each patient's case. By the way, Mr. Health Plan, if you're going to use me, in exchange for using me, you agree not to hold MCG liable for any possible damages, claim for damages arising from a decision you make based on information obtained through the site. Use that to challenge the issue. In addition to looking at the guideline, we use this strategy, and we wrote this. We dispute Dr. Tolson's decision to deny authorization for inpatient rehab based on a lack of authorization because two of Cooper's treating doctors with expertise in this field have documented the medical necessity of the requested service, and Dr. Tolson does not have the clinical expertise to make an appropriate medical decision in this matter. And we filed this with the Arizona Medical Board. This is a lot of fun because as we challenged the actual issue, we sent it to Aetna Banner and we filed it with the Arizona Medical Board. And then we quoted this particular law, and I'm going to give it to you in your handouts that we passed out to you. There's a cheat sheet. It's going to be hard for you to write without a table today. So you can put it in your phone, or if you found a way to write, you can write it. But here's a great law under 29 CFR 2560.503-1 H2. 29 CFR 2560.503-1 H2. It says this, that the plan, the ERISA plan, must under III provide that in deciding an appeal of any adverse determination that's based in whole or in part on a medical judgment, including determinations with regard to whether a particular treatment, drug, or other item is experimental, investigational, or not medically necessary or appropriate, the appropriate named fiduciary shall consult with a health care professional who has the appropriate training and experience in the field of medicine involved in the medical judgment. Well, you probably remember in this case, I told you that we had some specialized rare neural doctors who had a special interest in neurological disorders, and we talked about some of their biography. But in this same challenge, we found that Dr. Tolson was an anesthesiologist. In other words, he was incompetent to evaluate the specific issues presented in this particular denial. We also quoted the MCG guideline that I just shared with you right now, and we really tore apart his denial because we noticed that they didn't apply the patient's medical circumstances in this scenario. How do you know? You want to see proof where they're saying the Milliman guideline says this, but the patient's red blood count or white blood count was X, Y, and Z. That proves they went in the medical record and they're applying it. That's really important. But also the question is, who did it? So we challenged it. This was sent on February 19th, 2019. See that? The next day, the mom wrote this to me. Cooper has just been approved for, 8 weeks or 6 weeks? 6 weeks of rehab. Now I have to see if his spot's still available at KKI. Thank you. Thank you. Thank you. She wrote this later as an update. Cooper has been in intensive rehab at KKI for 10 weeks now and has made huge functional gains thanks to the therapy and medical care he's now receiving. He is off the ventilator, the machine that breathes for him, and well on his way to getting his trach reversed. He started eating by mouth and making sounds again. I had not heard my baby cry in 6 months. And what a moment it was to finally hear him again. She wrote this later. Cooper's making so much progress. It's truly incredible. I watched him take his first steps a few days ago, something I wasn't sure I would ever see. I can't even explain how incredible this place is and what they do for children with spinal cord injuries. Thank you again for getting us here. These are the stories of the patients that we represent, that we may never know or understand the impact of our appeal, how we impacted their life by fighting an uphill battle on their behalf. Our organization, we have a mission to provide claims representation and patient advocacy that restricts third-party payers from making medically inappropriate decisions. We do this pursuant to a case called Wickline versus State. If you're writing today in your phone, you can write Wickline versus State. In the case of Wickline versus State, Lois Wickline was cleared for an abdominal aorta surgery. Her treating doctor wanted to observe her condition for 8 days. Medi-Cal or Medicaid in California would only grant a 4-day authorization. The doctor, out of fear of retaliation or fear of not being paid, released the patient after 4 days. She suffered an infection in her leg that resulted in the leg amputation. So we understand we have an obligation to challenge and protest decisions that impair our ability to render quality care to patients, because ultimately we recognize that every case represents a human life. Healthcare is a law to be defended. I want you to write this term down if you're writing with me. We advocate, or I advocate, for medically appropriate healthcare for citizens in my state. I advocate for medically appropriate healthcare for citizens in my state. Now, will you just repeat that with me? Say it. I advocate for medically appropriate healthcare for citizens in my state. Now, when we're saying that with great conviction, not uncertainty, but understanding that that is the role that we have. We have an obligation to be an advocate. We're more than our name tag. We're more than directors. We're more than billers. We're more than managers, more than supervisors. We're more than COOs. We're more than patient financial service reps. We are advocates. Write that term down, advocate. An advocate is one who defends the rights and causes of another. I defend the rights and causes of my patients. I want to give you 4 ways to be a champion for medically appropriate healthcare. 4 ways to advocate for medically appropriate healthcare before we jump into our exercise today. Number 1, ask yourself this question: can I do this? Can I do this? Because the purpose of the law, why use administrative laws, why streamline them in the front and the mid and the back end of revenue cycle? Because the purpose of the law is to bring me to a place of recovery. Give you an example of just some things I want to show you real quickly. We had a policy challenge some years ago because we had certain Medicare Advantage plans who were not permitting our provider members to do a peer-to-peer review. Or they would plan one and then it would never happen. Or they would say, we can do one, and they would give these little restricted windows that we just couldn't make it happen. You ever try to plan a peer-to-peer with a doctor in your hospital? It's like pulling teeth at times, right? So they would give us these restrictive time frames, and I don't like mentioning names of payers, Humana, and they would do this. So we had to make a decision to challenge the issue. And as we begin to challenge it, we looked at this particular section of law that we'll go over today, where it shows that Medicare Advantage Medicare Advantage organizations are financially responsible for post-stabilization care services when they've been approved, number 1, or they render service, or the provider renders services within 1 hour of the request. If the plan did not respond, after the 1 hour, they cannot be contacted, or there cannot be an agreement reached about the enrollee's care. The MA organizations are financially responsible when a planned physician either assumes responsibility for the enrollee's care at the treating facility or through transfer, when they reconsider and reach an agreement, or if they don't do any of that, the enrollee is then discharged. So we were seeing that there were plans out there that were failing to pre-approve care within 1 hour, then denying claims for medical necessity, even if ordered by a plan provider. And we pulled some things under a FOIA. Write that down, FOIA. A FOIA is a Freedom of Information Act request, where you can request how the government functions or why they created a certain law. You can request a document that substantiates why they made a certain decision. We wrote this to CMS. Said, hey, is it possible? Can you provide an electronic written copy of any document, SOP, or CMS directive that states that a plan can deny a claim or services for medical necessity if they fail to respond within 1 hour? And they gave us, or we found, the Federal Register, Volume 63, number 123, where it writes, we do not agree that the Medicare Advantage organization should have the absolute right to control the care that's given to the member when it does eventually respond and the 1 hour time period has elapsed. Safe transfer of responsibility should occur with the needs and the condition of the patient as the primary concern so that quality of care is not compromised. We also saw that CMS sent us a copy of the Medicare Managed Care Manual, Chapter 4, Section 20.5.3. Now, this is the manual. This section is the manual. Everything here. CMS in Baltimore typed this for us. And it writes this: when a treating physician is contracted with the plan, CMS views him or her as the plan. Let that sit for a minute. And I begin to think, because I was doing ALJ hearings 15 years ago, and it was for ambulance providers, and I won like 80% of my cases. And I remember the first case I ever won, CMS said it was for repetitive transports to dialysis. They said if the nephrologist is good enough to administer dialysis, they're good enough to determine how the patient needs to get to dialysis. And they quoted this to me 15 years ago, and I never applied it for hospitals. They said when the treating physician is contracted with the plan, CMS views him or her as the plan for the purposes of our rules and guidance. All of a sudden, lights went off in our head. We started realizing there's a remedy for contracted providers. We did a FOIA for this, and we got the same Medicare Managed Care Manual, Chapter 160, and it wrote this. Notice, CMS considers a contracted provider an agent of the plan. What's the difference between this slide and the previous slide? What word is different? You see that? This one says when a treating what? This one says when a treating what? Contracted provider, physician, or hospital. Lights start coming up as we saw this. So we started creating challenges. We also noticed they gave us this section under the chapter on Chapter 4, Section 10.16, and it talks about how decisions for medical necessity must be based on the medical necessity of plan covered services, including emergency, urgent care, post-stabilization, based on internal policies, including coverage criteria no more restrictive than original Medicare. In other words, if Medicare covers it, they have to cover it. That's under, by the way, that's under 42 CFR 422.101. That states that they must cover what Medicare Part A and Part B covers, Medicare Advantage plans. It has to be reviewed and approved by the medical director, where appropriate, involvement of the organization's medical director, and they have to consider the enrollee's medical history, diagnoses, conditions, functional status, physician recommendations, and clinical notes. I love this last part. Furthermore, if the plan approved the furnishing of a service through an advanced determination of coverage, it may not deny coverage later on the basis of a lack of medical necessity. Now, I want you to just catch this for a minute, because I want to show you real quickly several ways a person could challenge a medical necessity case as a non-physician without conducting a medical review, without providing medical records. I want to show you that. Number one, we want to look to see if the treating physician or the provider is contracted. Why? Talk to me. Because they're an agent of the plan, and their decision constitutes a favorable determination. Now, you might be asking yourself, does that mean that we can self-refer? Can our hospitalist who works for the hospital admit a patient, and is the plan obligated to pay for what we as a contracted provider did in the admitting process? According to this, absolutely. We started creating arguments. Here's one. Per CMS policy, contracted providers are considered agents of the plan. Per CMS commentary included in its response to our July 9th, 18 FOIA request, when a treating physician is contracted with the plan, CMS views him or her as the plan. Then we went and jumped into Chapter 4 that talks about a contracted provider. Their decision constitutes a favorable organization determination. All right, how do I prove it? So I'm looking to see, number one, is my treating doctor, is the cardiologist, are they affiliated with Humana or the payer? And if they are, I'm pulling their profile on Humana's website. And it becomes a part of my exhibits when I'm sending my appeal. This is your doctor who's affiliated or contracted with you. We have a case study that shows this from a contracted provider perspective. We had an appeal that we had submitted out for one of our Minnesota providers. And Maximus said, we agree with you. We will tell the plan to pay for these services. Here's why they told them. The rules say that a contract plan provider is an agent of the plan. Services or referrals obtained from a plan provider are viewed as what? Can you see that? Plan approved. Unless notice is given that services will not be covered. When a plan provider gives or refers an enrollee for a service the enrollee reasonably believes is covered by the plan, they're held harmless. And of course, they went on and explained how this claim involved a patient who was transferred from one hospital for a higher level of care. And because the hospital, the transferring hospital, was a contracted provider, even though the receiving hospital never got an authorization, it was plan provider approved. Just showing you how we can challenge issues and bypass improper or unnecessary medical records requests or medical reviews by actual plans. So we've talked about, can I do this? I've given you some proof that we can apply administrative laws or CMS regulations and challenge payers. Can I process this? Can I process this? We begin to ask ourselves, what if we could prevent denials? What if we had the ability before, let's talk about that for a minute. From the time the patient leaves to the time the bill drops, what's the average amount of time frame in that gap? How long does it take for us to drop a bill from discharge? Give me a range. What do you think? Give me a range. 7 days. Anyone else? Give me different ones. If it's over 7 days, don't tell us. But anyway, it's okay. It's okay. Don't worry about it. I get it. I get it. All right. So watch this. What if in those 7 days we took the tracking and reference number and we gave it to one or two people who were in charge of using these laws to challenge the payer and tell them, Mr. Health Plan, please be advised we contacted you on January 10th. You failed to respond within 60 minutes. Pursuant to 42 CFR 422.113, because you failed to pre-approve the care, did not assume care of the patient, did not reconsider and give us an authorization, Section C3 of 422.113 states that your financial responsibility ends on patient discharge. What if we took those 7 days to convert the tracking and reference number to an authorization? We could prevent back-end denials. So we began to train our provider members how to create a clinical denial prevention unit. And for those that didn't have the budget or the workflow or the FTEs to do this, we became an extension of their department. And every time a patient was in the house, a tracking and reference number or a concurrent denial, they would give it to us. It's a challenge, real simple. And we've had phenomenal results, and I'll show you some of that in just a minute. Whether it's for MA plans or whether it's for ERISA plans, we've seen just phenomenal results with this. Give you another section of law before I jump to this ERISA case study. So, what time is the session in today? Is it 12? 12. All right. Stay with me. Don't go anywhere. Stay right there. Stay right there. Don't you go anywhere right now. Let's see here. I think I want to show you something. And I think it's going to help you if I show you this. Like never done what I'm doing right now. I think this will help you. All right. I completely just changed the PowerPoint right in front of you. Okay? But I think this will help you. And I want to give you quickly just some regulations that deal with emergency and post-stabilization responsibility by plans, okay? Before I jump into the ERISA case study. And this will help you if you want to create a clinical denial prevention unit at your organization. All right, here are some of the laws. And again, if you're writing, you can write them. I did give you a cheat sheet. And on one side, it says denial or stall tactic. On the other side, it says suggested legal response. You can write on there if you have something to write on. If not, I would just record these in your phone or something so you can take them back to your office. All right, so 42 CFR 422.566A. It talks about the plans having a responsibility or a procedure for making timely organization determinations. And then they define what is an actionable organization determination, which are any of the following. Now consider this, that an organization determination is the plan's determination or their initial response to something. So if you submit a claim, that initial denial is an organization determination, or that decision, if they're going to pay for out of area renal dialysis, emergency, post aid, or urgent services, upon presentation of the claim, that is an organization determination. Okay, that's number one. Look at what else is an organization determination. The MA organization's refusal to provide or pay for services in whole or part, including the type or level of services. So their decision to deny something that was inpatient to observation when the patient's already gone. In fact, can we agree that a majority of those denials come after the patient's gone, right? That decision, we can mark it as untimely. You with me? Because they should have made that decision, whether it's going to be in whole or part, if they were going to cover the level of service of inpatient versus observation, timely. Keep using this word timely. What's timely? We're going to get there in just a minute. Their failure to approve and furnish, arrange for, provide payment for health services in a timely manner, or provide the enrollee with timely notice of an adverse determination. These are all organization determinations. We know that when it says failure to provide payment in a timely manner, again, the question is, what is timely? Under 42 CFR 422.520, plans have 30 to 60 days to reimburse claims, depending on if you're contracted or not. 42 CFR 422.520. That decision to pay you must be timely. Notice, who must review organization determinations? If the MA plan expects to issue a partially or fully adverse medical necessity or substantively equivalent term used to describe the concept of medical necessity, decision based on the initial review of the request. We talked about that word initial, right? The organization determination must be reviewed by what? By a physician, other appropriate healthcare professional with sufficient medical and other expertise, including knowledge of Medicare coverage criteria before they issue the decision. Who can make the initial denials? Must be a physician that's competent, right? So I talked about giving you several ways to challenge medical necessity denials as a non-physician. Number one, I gave you, hey, are you contracted, or is the physician contracted who did the self-referral? Number one. Number two, was the reviewer, right? Was the reviewer competent to make that decision? That's how we beat Cooper's case. We never fought medical necessity. We never gave them medical records. We simply said, you're an anesthesiologist. They were a neuro specialist. You're wrong. I'm telling. Right? That's all we basically did. So we're talking about ways that we can challenge. Look to see if you're contracted. Find out who denied the care. Some of you have. Does any of you have a peer-to-peer process in your hospital? Anyone have that? Okay. Who sets them up? Talk to me. Who sets the peer-to-peer up in your hospital? Case managers? Okay. And is it normally a concurrent thing you're doing while the patient's there or afterwards? Both. Okay. So, two things. Either, whether it's while the patient is there or after, we have a peer-to-peer form that we've created. I've given you a packet. In the packet, there is a form. That form is simply because we give professional development of units for this class, and we'll record your hours and give you a certificate if you need that. But also, it's for you to tell me what you need. So on the bottom of that form, if you're writing with it, you can write something like send peer-to-peer form, and I'll send you a peer-to-peer form that we use that we want our peer-to-peer folks to use when they're conducting the peer-to-peer. And specifically, we want to find out, hey, who's meeting with Doc? Who's meeting with our doctor? Is that person skilled? Do they have the sufficient medical and other expertise to make that determination, to even conduct the peer-to-peer? So we encourage our our case managers, when you're setting it up for the doc, get the full name. You should bookmark the state medical board in your state and look up that doctor to see what their specialty was, to see if they were an anesthesiologist making a decision for a cardiologist referral. Talking about how to challenge issues on grounds of medical necessity as a non-physician, because for us, we will only use our physician advisor if it's a true medical necessity issue. I want you to write that down. We only challenge him with that if it's a true medical necessity issue. In other words, we couldn't prove that we were contracted. We couldn't prove there was a competency issue. They were competent, they had the same specialty, or they were skilled in that field of medicine. Or if we find proof that we never made contact. Okay? So let's go into that. Let's jump into that a little bit more. And the reason why I pulled this into this PowerPoint right now is because without you having tables to write on, it can be very difficult to do the exercise portion. So I'm trying to fill the exercise portion up with this, and we'll still get to that, and I'll show you how to do it. But I want to make sure I give you something of substance that has the ability to help you create some of this. So watch this. Write this down. 4.2 CFR. We've been talking about timely. 4.2 CFR 422.113. We said that plans have to make a timely organization determination, right? They have to decide the level of care timely. When we provide that initial request for an authorization. All right, talk for a moment. How do you make that request? Do you make it by phone? Do you make it by fax? By e-portal? By smoke signal in the air? How do you make the request? Patients here, we need authorization. Talk to me. How do you do it? How do you make the request to the insurance company? Hey, this is it. Electronically through a portal. Okay. And if it's Medicare Advantage, are we tracking their response in that portal? In fact, I don't even know what's happening in this region with your Medicare Advantage. You could have great Medicare Advantage plans. Do your Medicare Advantage plans respond within an hour? No, shaking. It's good. So you're like everyone else. Don't worry about that. We're like everyone else. We're all in the same bucket. They rarely do that. All right. So when are they responding? How much time are they taking? Talk to me. Give me an average of time they're taking. 14 days. That's a problem, by the way. That is a problem in consideration of what I'm going to show you. So they could respond in 14 days, but it means the first 14 days they're financially responsible for. And as of the 14th day, they can then make the decisions you'll see in the law. I'm going to show you now. Okay? You could respond with notification 3 days later. And because you responded late, if it wasn't over a weekend, they could ask you for medical records for those 3 days. And then from the date that you requested the authorization, they have 60 minutes from there. Let's just jump into it a little bit, okay? So, number one, the MA organization is under 4.2 CFR 422.113. They're financially responsible for post-stay care obtained in or out of network that are, watch this, pre-approved by a plan provider. That's the doctor or the contract hospital. That's a plan provider if you pre-approve it. You're an agent of the plan, or they're responsible if it's pre-approved by a MA organization rep. I don't know if you call it that, but services can be pre-approved either by the plan or by the plan provider. Please document that and distinguish that if you haven't. It could either be approved by you if you're contracted, or the physician if they're contracted, or the MA organization rep. And if they pre-approve it, if any of these entities pre-approve it, they're financially responsible to pay for that care, even if later they find out the person wasn't covered. They're responsible, okay? All right, let's continue. Under 42 CFR 422.113, C2 double I. We just read single I here. C2 double I, the plans are financially responsible for post-aid care in and out of network that are not pre-approved by a plan provider or other MA organization rep, but administered to maintain the enrollee stabilized condition within 1 hour of the request to the MA organization for pre-approval of further post-aid care services. They're also under C triple I, financially, C2 triple I, financially responsible for post-aid services in and out of network, not pre-approved by a plan provider or other MA organization rep, but administered to maintain, improve, or resolve the enrollee stabilized condition if the plan does not respond to a request for what? What is pre-approval? Watch this. Not a request for a tracking number, not a request for a reference number, which is what they're giving you, which is against the law. If they don't respond to our request for an approval or authorization within 1 hour, or the plan cannot be contacted, or they don't reach an agreement, they can reconsider their decision, the law states that they're also financially responsible for services to maintain, improve, or resolve the enrollee's stabilized condition. When would we ever use this one? The MA organization cannot be contacted. When though? Good. They're not answering why. Because it is after hours, on a weekend, right? Saturday or Sunday. So whenever you see something, whenever you see that your hospital did not request an authorization same day. So for instance, let's say the patient came on the 10th and we didn't notify until the 13th. You must go into a fact-finding mission to find out what? What are you looking for in that scenario? 10th, we didn't contact until the 13th. What are you looking for? You have the week. Maybe the 10th was a Friday and the 13th was a Monday. So my timeline is now going to say, please be advised on Friday, 110, excellent, 110, the date is 110, at 8 p.m., the patient was admitted with severe crushing chest pains. On Monday, January 13th, in parentheses, the next business day, we made contact. And then you're using this section here, can be contacted. Now, they're going to fight it. If you're the plan, and I'm telling you, you couldn't be contacted, how are you going to fight it? Talk to me. Be the plan. Let's role reverse. You're the plan. I'm telling you, you couldn't be contacted. What are you going to say to me? Let's be creative. What do you think they're going to say to me? Show me. You're going to probably try to prove what? That we could be, document, hey, prove you tried. Question is, were you there? Right? So what we've done is we've told provider members, well, your problem payers only. You can do it for all of them later as time progresses. Problem payers who keep doing this, go to their website and look at their authorization sheet that shows their hours. And if it says Monday through Friday, or Monday through Friday, 7 to 7, or 6 to 6, whatever it might say, you can print that sheet out as an exhibit to show what? You could not be contacted. All right, what if you can't find that? It's hidden in some secret page on the internet They've got it hidden somewhere. You can't even find it. Place the burden of proof on them. Patient came in over the weekend on Saturday. You cannot be contacted. We called you that Monday. Make them then prove, no, we could be contacted. Here is the after hours phone number. Now, from a procedure standpoint, you have figured out how to make after hour contacts. Okay. So here's a question. Are there any health plans in here? Any health plans? Okay. No health plans? Okay. All right. Here's one health plan. Here's one health plan. Here's the question right now. The question I want you to ask yourself is, how many of you are even looking for, you've created a matrix. If I worked for you, the hospital, this is the health plan. She's a good health plan, okay? She's a wonderful health plan. Okay, here's the hospital. Here's the health plan. You're the hospital. I work for you. What type of matrix would you give me to tell me what type of contact I have to make to her health plan? What's the name of your plan? Age Right. What type of matrix can show me for Age Right we have to make a phone call and a fax, or for Age Right everything's e-portal, right? Maybe in that matrix, when you're showing me how to make contact, sorry, is anyone else not using portal? Anyone not using portal? Anyone using calls or faxes? I'm just curious. Anyone calling or faxing when you make a notification? Everyone's using portal? Okay, good to know. So we have some regions where they're not always using that. And furthermore, if they are using portal, they can't document if they're getting that response back within 60 minutes. So we need to create a matrix that shows us what Age Right is requesting, what Humana is requesting, what Blue Cross is requesting, and abide by that. We have certain attorneys at agencies who told our provider members, for instance, in California, it says you only have to make one phone call. And they said, don't just do that. We want you to fax as well, even though the law doesn't say it, and keep a fax confirmation sheet of what you submitted. With the portal submission, it gives you a receipt showing that you've done it, right? We've got to somehow get those scanned into documentation. So when a plan, not Age Right, says to us, hey, we never got that authorization request, we can go back and say, yes, we did send it. Here's a screenshot or confirmation of what we requested, and you failed to respond within 60 minutes. And we're trying to make sure that we have a system in place to work as a collaborator with the health plan. That's important. So we understand that plans are financially responsible if they don't respond to a pre-approval within 1 hour. We've had plans tell us it's impossible to respond within 1 hour. The law states they have to respond within 1 hour because they're keeping the beneficiary's needs supreme by doing that, making sure they're held harmless by any services they're going to receive from you. Even through an ABN process, they want to make sure they're protected in that sense. All right, so we're just talking about some of that. I love this next part under C2IIIC. In this situation, the MA plan must give the treating physician the opportunity to consult with the plan physician, and the treating doctor may continue with care of the patient until a plan physician is reached or one of these criteria I'm going to read to you are met. This is my favorite section. This marks the end of a Medicare Advantage care's financial responsibility. Number one, it says the MA organization's financial responsibility for post-aid care they've not pre-approved ends when a plan physician with privileges at your hospital assumes responsibility for the enrollee's care. Number two, a plan doctor assumes responsibility for the care through transfer. Number three, an MA organization rep and the treating doctor reach an agreement concerning the enrollee's care, or if none of these three take place and they have not pre-approved the care, their financial responsibility ends discharge. They don't pre-approve, so watch this. When they concurrently deny you, Mr. Health Plan, We understand there's a disagreement of care. We want to enter into a formal disagreement of care as our doctor believes that further inpatient care is needed. We ask that you have a planned physician with privileges at our hospital assume care for the patient, or a planned physician assume care through transfer, or you can reconsider your decision to keep the patient here. But if you fail to do any of these three and the patient stays until discharge, you're responsible for the entire stay. You've got to be able to create scripts, but also create great questions. All right, here's a great question. You can write it down. Mr. Health Plan, what statutory authority do you rely upon to deny this claim for medical necessity when you were contacted, did not respond in 60 minutes, and failed to assume responsibility of the enrollee's care before discharge? Just talking about questions. Because every law should produce a question that you can pose to an actual plan. If for some reason you have a plan that is making a decision to deny something, stating, hey, it's our policy to request medical records after the patient's already gone, please provide the statutory authority that you rely upon to request medical records or conduct a medical review for services that you're already financially responsible because you failed to do all of this, failed to respond in 60 minutes, failed to assume care of the actual patient. Please provide the statutory authority that exempts you from C3. Questions. So when you go to a doctor, they ask you questions. When you're in court, the attorney cross-examines with what? Questions. Under, you can write this down, 42 CFR 422.590. Let's make sure that this has the changed number. This is a training manual that we actually train with in the industry. Yeah. So under 422.590H, who must reconsider an adverse determination? Number one, a person or persons who are not involved in the original one. Right? If it's based on medical necessity or any substantively equivalent term used to describe the concept of medical necessity, the reconsidered determination must be made by a physician with expertise in the field of medicine. We're just giving you parallel. So in the initial decision, organization determination, under 422.566D, that initial decision must be made by a doctor with sufficient medical expertise. If you do an appeal or a reconsideration, that decision must be made by a doctor who has experience in the field of medicine. We're just talking about how to challenge issues, how to make a difference. Yeah, true. Thank you for bringing that up again. So we fight true medical necessity issues. That means for us, we first ask ourselves, okay, they denied for medical necessity. Was the plan contracted? Do they have to pay for it because the contract provider is the agent of the plan? If that's there, we fight that. All right, medical necessity issue. They denied it for that reason, but we see that the person was incompetent. We'll use that. And then thirdly, we look to see if contact was made. If contact wasn't made, we failed to respond or tell the payer the patient was there, we treat that as a true medical necessity issue. They have a right to do a retrospective review right away. If for some reason contact was made and they didn't respond to us, then we're using these sections of law, thank you, Kiet, for mentioning that demonstrate when their financial responsibility ends under 422.113 that we talked about. More than ever, I've had in the last 2 years, literally, I swear to you, CEOs of Medicare Advantage plans calling us to conduct a conference call to discuss all the outstanding issues, because every time we file a complaint, it could potentially take a hit on their star rating. Under 42 CFR 422.166, the filing of complaints can affect the star rating of plans. I've had 5 plans call me and say, can we talk? Can we discuss this issue? And we've had a chance to really challenge the issue and really instill preventative measures in place that change how they actually respond to our provider members, that can put corrective measures in place where providers weren't making the correct contact. They weren't calling the right phone number. We've been able to fix so much just working with them through this, and we've placed a regulatory stay on those 5 plans because they're working with us to help our provider members. All right, we talked about can I process this, and we talked about doing a clinical denial prevention unit. Here's an example of that, a work that we actually did with an ERISA plan in Illinois, and we requested an authorization for a patient that, to my understanding, this patient was still in-house. The services were partially authorized through the employer's previous TPA, Meriton Health, under an authorization. But on 1/1/22, the employer changed TPAs from Meriton to Blue Cross Blue Shield of Illinois. And they were unable to secure continued authorization for the inpatient admission. And you'll see that in our timeline, we build a human story. Patient presented to St. Charles with intra-abdominal and pelvic swelling. Here, we're trying to strike whatever consciousness that we have with the payer that we're dealing with to try to get an authorization, help them to see the seriousness of the actual issue. And of course, this tells a story of what happened. 2/21, the husband called St. Charles to verify that Meritain is responsible for this date of service, Blue Cross responsible for this date of service. And of course, we begin to quote laws just in trying to get it secure an authorization because it was being denied by the new TPA. On 3/17/22, Kelly with Blue Cross stated they cannot provide a retro auth for the case. And they failed to provide any summary plan description or governing plan document that shows retro auth requests are not allowed under the member's plan. So we requested a copy of all the plan documents listed here. Copy of all plan documents, SPDs that have existed at the time of the coverage policy. Updated summary plan descriptions for the last 3 years. Summary annual reports the last 3 years. Copy of the bargaining agreement, trust agreement, contract, other instrument, which the plan was established, all amendments since the establishment date to present. Copy of written policies, memoranda, minutes of meetings, other written documentation, addressing reimbursement timeframes, authorizations, retro authorization. And of course, we gave them till March 24th to give us an authorization. Remember, this clinical denial prevention unit only is in charge of getting authorizations. That's it. We simply requested authorization. March 23rd, we gave them to March 24th. And on Saturday, April 2nd, we got an authorization letter for the approval for the second part under Blue Cross Blue Shield. And I believe we just got payment on this. It's like $1 million claim. Just got payment on it 5 days ago. What if we wouldn't have tried to convert the authorization, but just bill it without taking this process? Now we're waiting until the patient's gone, right? We're waiting once the claim is submitted for a response. That's going to be a denial, right? We're having to appeal it from that time frame. That will be another 60 days. Providing medical records. We've shortened the time frame just by doing this before the claim was dropped. That's what a clinical denial prevention unit can do for you. So have you created letter libraries, law libraries, blurb libraries, Have you created fax cover sheets with laws, registration forms with laws, policies, procedures, checklists, KPIs, and metrics? We have something interesting called blurb libraries. Um, we never create from a blank, please write this down if you're writing, never create from a blank piece of paper. We've decided that we're going to have a blurb library. So we have a no claim on file blurb, a not medically necessary blurb, a retro authorization blurb, a timely filing blurb, a post-stabilization blurb, a coordination of benefits blurb, all based on jurisdiction. So we have a government blurb section. We have an ERISA blurb section. We have a Medicare Advantage blurb section. We have a VA blurb section. We have an HMO and PPO blurb section. So at any point, our people can go to this library and pull up this blurb for a conversation or for a letter. But you have to intentionally do something like that. We've created flowcharts and processes for provider members, trying to make sure we're delivering healthcare better, to work with our healthcare partners, our Medicare Advantage plans best. We want to make sure that we are collaborating with them in a powerful and profound way. So we create flowcharts of from the time the patient gets to us until it's denied in the peer-to-peer process. We've created documentation and rebuttal guidelines of how to document authorizations if no authorization was given. We've created disclaimers. Some of you on the provider side may have heard a disclaimer. Maybe, I'm not sure if you heard it out here in Oregon, but you get an authorization, you rely on that authorization, and then they'll tell you while you're waiting on hold, this authorization does not constitute what? Guarantee of payment of the claim, right? Yeah, subject to eligibility, right? And we just said, they're having way too much fun with the disclaimers. We just start creating disclaimers. And one of the disclaimers that we created was here, Mr. Plan, please note that while you've issued a tracking and reference number for your patient, under existing Medicare law, plans are required within 60 minutes from initial contact to pre-approve post-aid care or assume care of the beneficiary via transfer or at our hospital if privileged. This tracking reference number does not satisfy your requirements under the law, but does constitute that contact was made in the event we do not receive an authorization number from you within 1 hour of this request. Your financial responsibility for post-aid care you've not pre-approved ends when you assume care of the patient, reach an agreement with our treating physician, or the patient is discharged. And we just start creating disclaimers. So when they're talking, they're repeating this to the actual plans as well. And we've also used this language on fax cover sheets. We've had some providers, when they're uploading the face sheet through an e-portal, some providers who are using that language in the upload. Also, just to remind the plan of that 60-minute requirement. Here's a copy of the fax cover sheet that we've created that has the law in it as well. There's also one for if there's a disagreement of care. If they decide to disagree while the patient's in the house, they can do that, but they can never disagree and leave and hide, rather. They can't say, hey, we're not going to pay for this care anymore. We disagree they should be in the hospital. They then have an obligation to assume care of the patient under Section C3 of 422.113. So we'll enter into a formal disagreement of care, asking them to effectuate transfer if the patient's stable. And if not, they can reconsider and reach an agreement to keep the patient here. But if we keep them and you never come back and assume care, your financial responsibility ends on patient discharge. We've created blurbs from the pandemic that deals with timely authorizations. We had some plans denying care at a time when they instilled a blurb, or they instilled just at the time waivers to request an authorization because hospitals were so full. We've created that. That's in your PowerPoint. Here's the time frame for Medicare Advantage plans. 60 days to request a reconsideration. You have that. Sure. Great question. Great question. Great question. These only apply, these here, to Medicare Advantage plans. If you're looking for a time frame for a commercial or managed Medicaid plan in Oregon, the bottom of your registration form, if you will tell me what you're looking for in terms of a time frame, I will give you what we might have in our library and then refer you to a program that we use called Rev Assurance as well. That kind of helps establish or gives you or points you to the time frames that Kiet is speaking about. Great point. This is only Medicare Advantage, only. Okay. All right. So you've got time frames here to request a determination listed here as well. We help our providers manage denials. I don't know if you do this. Just talk to me. Do you have a system or have the means to flag a denial as not medically necessary, unauthorized, and then pull a report of all 50 cases that are unauthorized for humanity? Can you do that? All right. So we've created that as well. Notice when we've created it, we've done it by jurisdiction. So we have an HMO section, and then we have a similar section for PPOs, for MAs. Do I have it? Yeah, there's PPOs. Here's at the very bottom, we start Medi-Cal or Medicaid. Then it goes to the VA, right? Why is that important? Why are the jurisdictions important? What do you think? The body, but that's going to, and watch this, each jurisdiction will change what? Change the laws talking about the time frame you have to appeal, right? Time frame for authorizations. Stay there. Let's see if I bought this. I may not have it, but let's just check it. And if I do have it, I may not have. Okay, maybe. Let's see here. Oregon. So Oregon doesn't have a time frame for post-legalization. But to Kiet's point, there's a Medicaid managed care law that governs the time frames that Medicaid managed care plans have to respond to you for an authorization. You right now, it's OR 410 141 0140. OAR 410 141 0140. Say it one more time. OAR 410 141 0140, 6 small case B. And it just deals with authorizations request. And to Kiet's point, I'm looking at one of our cheat sheets for Oregon, and 3 of the topics refer to Medicaid managed care law because there isn't a commercial law for it. Retroactive denials, post-stabilization timeframes, and notice requirements if they deny something as well. There's a qualified reviewer law in Oregon. If for some reason it's being denied by someone not competent, I'm going to give you that one. It's ORS 743B. ORS 743B. 0.422. 2. Talks about a licensed specialist being responsible for all final recommendations, consulting with specialists to make that decision. So the jurisdiction here, this is really important because it helps you determine timeframes. Okay, what timeframes do I have for Medicare Advantage versus commercial? What timeframes do I have to appeal for ERISA versus Medicare Advantage? So we do it this way instead, so we can always remind our staff members of timeframes. For the VA, your favorite payer, I'm sure, you have a year to file a notice of disagreement. That's their appeal. For MA plans, you have 60 days to submit a reconsideration. That's their appeal notice. For ERISA, you have 6 months. So we have to know that for the purposes of doing it. Can I automate this? We've automated this by we have a cheat sheet like this that in-house we use for our help desk. This is the one I just looked on for you to give you those laws. And you can't see it here, but below, tabbed out, are the 30 states, 25 or 30 states that we work in. And we've created also a program called, it's an online encyclopedia that has denial topics for about 25 to 30 states. We have providers in 25 or 30 states using it, and it gives you denial topics by medical necessity. You pull it up, it gives you what the law says in that particular state. It also gives you a script that you can create to talk to the plan, who the reg agency is. You can generate an appeal through Microsoft Word through this particular program as well that looks like this. And here are some of the other items. Affidavit, appeal, demand that are provided in the actual program. So we've automated this so that we can tell our staff members and provider members, we've done the research for you. Don't go and look for it. You can find it here through Rev Assurance online. We have a help desk that provider members can actually submit tickets. They can say, hey, I've got a patient from Tennessee. What is the retroactive law for Tennessee? And we'll have it go through our help desk, and we'll provide them with the suggested legal response or administrative law for that particular state. Lastly, can I beat this? Can I beat this? So I've given you, there's a handout I've given you, and again, we don't have tables to do this, but I want to show you what I've done. I've given you a denial determination exercise. We believe in the importance of determining denials in mass so that we can do a mass enforcement. So instead of sending 50 individual letters for the same denial topic to the same plan, we will first do denial determination. And if they're the same denial with the same plan, we will do a mass enforcement. And in a spreadsheet, we will put a small timeline to explain what the patient or what the provider or what the payer rather failed to do. And so in that handout I've given you that you can do with your staff at your office, you'll see a timeline. 11/1/15, patient presented to the ED, severe crushing chest pains. 11/1/15, hospital called careless senior plan. We have fun making that up. And stated that the patient was eligible, effective 5/1/12 to current, issued a tracking number. On 11/2, hospital faxed a face sheet to careless senior plan, notifying of the patient's admission and requesting authorization per what law? What law? Give it to you earlier. What law? Oh, yeah, because got to figure that out, right? 60-minute law, right? 42 CFR 422.113 is when we make that request for authorization per that. So when you get to that page, you can also point to them. You can give them several laws. So give them 422.113, give them 422.566. Just give them those two, and then ask them to fill in the blank of what law would support us requesting authorization or pre-approval. On 11/5/15, patient discharged without any disapproval from Careless. We submitted the claim to Careless electronically. We called Careless, and the rep stated the claim was denied as not medically necessary, requesting medical records. What's wrong with that? We already called you. You didn't respond in 60 minutes, right? The patient's already gone. You can make that decision concurrently. You can't make it retrospectively if I gave you a chance to come and get them. So you can easily challenge your staff as you're doing this exercise. Hey, what's wrong with this request? Ask them to explain why. Make them point to the law that talks about 60 minutes as Lisa or the Oregon Ducks fan did, okay? Make them point to that. That's important. And then, of course, we're going to ask, what's the denial? Okay, so based on this, I'm walking you through so you can do this with your staff. Based on this, what's the denial? What's the planned denial? Sorry, not what's the planned denial. What's the denial on this? Medical necessity, good. But what are we fighting? We're fighting timely notification. We're not fighting medical. We're fighting the technicality of them failing to respond within 60 minutes. Big difference, right? So when you're doing this, you can also have a conversation. All right, what's the denial? Medical necessity, but what are we fighting? What's the denial? Medical necessity, but what are we fighting? You drive that home. Then, of course, what's the jurisdiction? Talk to me. Based on the timeline, what's the jurisdiction? You have to know this. It's careless senior plan, right? You got to know that. So we know it's MA, right? MA here. And then, of course, we provide a couple of sample questions, burden of proof questions. Please provide the statutory authority that CareLess relies upon to request what? For statutorily deemed authorized services. To request what? Medical records for statutorily deemed authorized services. As you know, contact was made with the plan on this date, and CareLess issued a tracking or reference number. Here, plan failed. CareLess failed to approve care within 1 hour of the request, failed to assume care via a physician with privileges at the hospital, failed to enter into an agreement with the treating doctor. Therefore, your financial responsibility ended upon patient discharge. And then I've given you some sample denial scenarios to create scripts listed here. All right? You can write them and then have your staff members write rebuttals based on the law you just taught them how to respond to these denial scenarios. We didn't go over this, but our physician determined the patient was stable for transfer 2 days prior to the date that they left. Under this section of law, 422113B3, it states the treating doctor determines if the patient is safe for discharge or transfer, and that decision is binding on the MA plan. These are just some things that you can do. I'd in fact encourage you to have your staff really read the entire section of 113 and 566. It's a great section. Let me create some other stuff here. Listen, my time is up, but I want to encourage you as advocates, we don't show partiality. We work both small and big cases alike. We collaborate when cases are too hard for us. We aren't afraid of anyone. And we had bracelets made of this years ago, WNITTF. We're not in this to fail. We refuse to fail in life, in healthcare, in advocacy, in marriage, in raising kids. We're not in this to fail. All right. Thank you. I appreciate you. You've been awesome. Thanks for tolerating me a second session. Have an awesome night. Take care now.